So, Mike, I don't know if you had a chance to watch the...
The broadcast is now starting. All attendees are in listen-only mode.
Not sure, Mike, if you got a chance to watch the Rays and the Brewers last night, but I was surprised and happy to see Matt Garza. Still think he should be a Ray.
I've been sorry to see them get rid of a lot of people who I think should still be Rays. I'm just hoping they don't trade David Price.
Well, don't they have a... Do they have a July 31st deadline, or is that just when people speculate it would be done if it was going to be done? Or is there actually something that would compel them to do it by then?
Well, that's the deadline for trading without having to put somebody on the waiver wire.
Okay. Well, I hope he can stay. What I like about that team is, you know, invariably Joe Madden is able to take, even though he's getting new players all the time because he's losing, you know, so many quality players, manages within the confines of a year to get him back, you know, in, you know, playoff contention, if not almost playoff contention. It's he's an amazing coach.
Well, one of the things I like is that I've never seen a rain out there. I've been to a lot of games in St. Petersburg, but not one has been rained out, and it's always 72 degrees.
People tell me that if they ever open an outdoor stadium, that's it for traveling to see them because of, you know, humidity, rain, lightning, sunburn, and delays.
Well, I went down to the new Marlins Stadium either last season or the season before, whenever their first season was, and that is it's a beautiful stadium, and they, you know, kept the roof closed for part of it. They opened it up toward the, you know, at the end of the game so they could have a fireworks show, but with the roof closed and you know, the air conditioning on. What a beautiful park to watch a ball game in. Unfortunately, that was a year that the Marlins were just terrible. So, you know, the worst thing that was going on in there was the baseball.
Oh.
But, you know, they've improved this year, and I would like to go back down there and see another game.
Well, both Miami and Tampa, I think, are right now on some pretty good runs. If I understood correctly, I finished watching the Rays, flipped one channel down on the dial, and watched the Marlins. And I think the announcers were saying in their post-game wrap-up that I think they won 9 out of 10 or something, so that's exciting. I see that folks are joining us. We are going to start the actual webinar presentation right at 11 o'clock, so in about 3 minutes. But what I'll share with those of you who are online right now is that everybody who's in attendance, except for Mike and myself, will be on mute, and hopefully you all can see you know, the first slide of the presentation, Mediating Probate Cases to Settlement. Since everybody is going to be on mute, we won't be able to answer your questions live, but you can text us in the chat window on your control panel. If you look to the lower right, you'll see an area where you can type a message. When we get those messages, we will, you know, do our best to try to address them within the confines of the presentation. But if not, perhaps Mike or I will be able to email you a response subsequent to the presentation. As you look at your screen, you should see a control panel, and there's an orange arrow for those of you who've never attended a webinar based on this technology before. You just need to know that that orange rectangle with the arrow pointing to the right side of your screen is a way for you to minimize your control panel. And you can move that to the right, get it out of the way, and get a cleaner, more complete look at each one of the slides. But again, if anybody attending would like to send us a question, you'll be able to use the chat function. Again, once you open up your control panel, look to the lower right-hand part of that control panel. You'll see an area where you can type your message here, and we will be tracking those. And like I said, if we're unable to answer them during the presentation, we will certainly be able to email you all subsequently. And Mike, your favorite team, going back to baseball before we start this presentation, you were mentioning before we went on the air, the Atlanta Braves is your favorite ball team?
Oh, I've been watching them since I was, probably 10, if not younger. Whenever Ted Turner owned the team and had them on TV
There you
every
go.
single night.
Every night. My dad would watch it every night, so by default I would watch it every night. And I remember falling asleep on the floor in front of the TV listening to the announcers call the Braves games.
My son and I met Dale Murphy, who's a well, he's not in the Hall of Fame, but he was a very famous Braves player back in the 70s, and I met him at a spring training game and introduced my son and all that. And I told him, I said, I've been watching the Braves since Ted Turner had them on twice a day in the 70s. And his comment to me was, one, he expressed his appreciation, but he said, boy, you watched a lot of really bad baseball.
They did have ups and downs, that's for sure. And Mike, I'm looking at the clock. It's 11 o'clock, and
Okay.
I know that there's some folks already on line right now, and others will be joining us. So we will go ahead and start the presentation.
Okay. And Richard, I don't know if it's just me, but there's a little bit of fading in and out of your microphone. So I don't know if you need to get closer or twist your head or...
I'm going to hold one arm out the window, raise my left leg over here, and
But the aluminum foil on
grab
your
onto
head.
the aluminum foil. Hopefully,
All right.
hopefully it's not going to be a distraction. Does that sound any better?
That's much better.
Okay, terrific.
Must be that aluminum foil.
Thank you. It is. Thank you for pointing it out. Well, good afternoon, everyone. My name is Richard Lord, and you've also been hearing the voice of Michael Orfinger. And today's presentation is entitled Mediating Probate Cases to Settlement. This is another one of our continuing series of webinar presentations that Upchurch Watson White Max Mediation Group is proud to put on in conjunction with the University of Florida Levin College of Law Institute for Dispute Resolution. I want to introduce my colleague Michael Orfinger. If you all haven't met him, I'm going to say a few things that many of you will know. If you've never met him, you're in for a treat. He's a very knowledgeable presenter on dispute resolution, and in particular this topic. Mike became a mediation panelist with Upchurch Watson White Max in 2001, and he's been a shareholder here since 2004. He is not only a Florida Supreme Court certified circuit civil and appellate mediator, he's also a qualified arbitrator and is a approved primary trainer for appellate mediation certification. There aren't too many of those. Before becoming a mediator, Mike practiced primarily in the commercial litigation, real estate, and insurance defense fields. And he is a graduate of Wake Forest and the University of Florida College of Law. He became a member of the bar in 1989, and more recently, many of you may know, has been elected unopposed to the bench. He will be presiding as a circuit judge in the 7th Judicial Circuit starting in January of 2015. And I know that I've enjoyed working with Mike for all these years. I'm going to miss him when he's on the bench, and I know that he's going to do a fine job for the 7th Judicial Circuit. At the end of this presentation, you're going to see a slide that will have the CLE numbers. I can say that we've been approved for 1.5 hours of general CLE credit, and we also will have credit for certification in elder law, marital and family law, and wills, trusts, and estates as well. So, Mike, in just a minute, I'll hand it off to you, but for those who have joined us since I initially made reference to the control panel, you all should see the first slide. You all should see a control panel to the right. If not, that means you have your control panel closed by using that rectangular orange or red arrow pointing to the right side of your screen. If you want to send us a question during the presentation, we will try to answer it during the presentation or perhaps afterwards by email, and you can do that by opening up the control panel, looking down to the lower right-hand portion, typing a message to us, and we'll do our best to answer it. Now, during the registration period, we did ask for folks registering to submit any questions that they would like answered during this webinar. We've received a good number of them, and we've tried to incorporate those in the preparation of the slides. So some of them will be answered as we cover the material, and there may be a few more that we will point out along the way. But thank you all for joining us. Mike, thank you for being here today, and I'll hand it off to you.
Okay, well, thank you. And I appreciate those kind words, Richard. I am going to miss having being here and working with everybody that I've worked with here over the past 13 years or so. When I take the bench in January, one of the things I always tell people when I'm mediating is that as the mediator, I still have to be enough of a lawyer to know the questions to ask, but I don't necessarily have to know the answers. And I guess one big change I'm about to go through is that, well, I have to know the answers again. And so we do have that, I do have that learning curve.
Fortunately, everybody who appears in front of you will be trying to give you the information you need to help you make those determinations.
Yeah,
you won't be flying blind.
The problem is that people tend to have different views of what the correct answer is. So, but anyway, I'm very much looking forward to that challenge. But I am so much going to miss working as a mediator in general, and specifically with all the people here at Upchurch Watson White Max. But today, let's talk about something that I have kind of fallen into over the years, which is probate litigation and probate mediation. You know, I've never been a family law mediator. Richard, I don't think you've ever been a family law mediator.
I have not.
But we all know people who have gone through divorces and whatnot. And, you know, I think with the possible exception of family law litigation, probate is probably the one that is going to be the most fraught with emotion. And a lot of the questions we got in advance of the session from those who registered for the event were geared towards, gee, how do you deal with family conflict? How do you deal with you know, estranged siblings? How do you deal with family members who haven't necessarily seen one another much and just hate each other? And that's, while we could answer that specific question by question, that's really what the thrust of this, what this program is about. And a lot of what we talk about today is going to be geared to just that discussion. So, but what I want to do is talk in general about why probate is a prime subject for mediation. Talk about some of the legal issues that we are most likely to be confronted with in probate litigation. I mean, there are always oddballs, but we can talk about the primary ones we're going to see. And then some tactics both for mediation advocates and mediators in conducting these mediations and maximizing their chances of success. You know, if you think about it, the probate system is designed to allocate the decedent's wealth first among the creditors, then among heirs at law, and then among other beneficiaries. So if you think about this from a purely legal standpoint, probate is a perfect topic for mediation because you could say, hey, it's all about the money. And it's a finite pot of money. And everybody has the same disadvantage, and that is the key witness, that is to say the testator or the testatrix, is dead. And we can't go ask that person, hey, when you wrote this document, what did you really mean? Or when you revoked this document, did you really intend to do that? Did you understand what the consequence would be? And you can't have a will contest while the testator is alive. That's, a very clear statutory prohibition. And the reason for that is that a will can be revoked at any time, and so nobody has any standing to contest a will because it's revocable at the pleasure of the testator. So everybody is left to argue after the testator is dead over whether the testamentary instruments are the correct testamentary instruments and whether they are accurate statements of the intent of someone who can no longer be questioned. Whoops, we went the wrong way there.
So certainly you have to deal with that amalgam of things that affect intrapersonal relations and perceptions, laden with emotion, psychology, all of those things that stand between the question and the answer of it being all about money.
Well, you do. I want to back up. I think we skipped a slide, and let's see. Here we go. Now here is a prime reason why probate lends itself to mediation. If you look at 733.815, this is in the probate code, there's a provision that basically says no matter what the testamentary documents say, interested persons can agree among themselves to alter their interests or their shares of the amounts to which they're entitled under a testamentary instrument by entering into a written contract. And although I don't have it written out here, the personal representative is bound by that agreement. Now, in a prior version of this seminar, the next part of this slide said, that sounds to me like they're talking about a mediation settlement agreement. Well, I always like it when I am later proven right by a court, because in late 2013, the First District came out with a case called Pierce versus Pierce. While it sounds like a family law case, it's actually a probate case. And it comes out and says 733.815 is a legislative expression of the long-held judicial preference for mediation and settlement of disputes. Now
Go ahead.
Go ahead.
Well, we had a question. Maybe it's now the time just to introduce the question. We had a question from one of the participants, or I should say one of the folks who registered, regarding dealing with indebted estates where multiple creditors' interests may have been affected by the outcome of the mediation.
Well, as you can see from this slide, which is not intended to address that specific point, but it really does, I think, apply. The probate estate, what I said earlier, it's a finite pot of money. It's finite only in the sense that it isn't going to get bigger. It's only going to get smaller. Usually by the time a mediation rolls around, in probate litigation, meaning the will's been offered for probate and somebody's filed a petition to contest it or to revoke probate or something like that, usually notice to creditors will have already been filed and published. And so if there are creditors of the estate, they are known, and the personal representative and all the interested parties will know what they are potentially dealing with. And, so sometimes if you can reach a settlement, in that instance you may end up allocating your settlement in terms of, okay, you're going to get X percent of what's left instead of X $1,000. You may not be in a position to guarantee a certain amount of money, but you may be in a position to guarantee a certain percentage of whatever amount remains. And again, by the time mediation rolls around, typically people will have a general idea of what the worst exposure is to the claims of creditors. When I was thinking about this, the shrinking pie concept, and was saying, look, it never gets any bigger than the pie we have over here on the left. Well, the litigation is making the PR spend money out of the estate. If it goes into litigation, in addition to whatever the personal representative is charging and whatever the personal representative's attorney is charging to probate the estate, the PR may have to hire a second attorney to handle the estate litigation, which is probably going to be paid on an hourly basis. If you are dealing with issues of capacity, if you're dealing with issues of undue influence, they may need to hire experts. Of course, experts are not going to work for free, and that money is going to be coming out of estate assets as well. Now, the contestant is also running up fees, and there's always or almost always a good argument to be made that the contestant is making some benefit to the estate, and by creating a benefit to the estate, even if it's clarifying the testator's intent, has somehow become deserving of attorney's fees, and so those fees may be coming out of the estate as well. But even if they're coming out of the contesting party's pocket or out of any recovery, certainly whoever is contesting the will is facing the point of diminishing returns at some point. And so, it is always possible, and at some point it's almost virtually certain, that you can win the battle legally on either side, but lose it financially. And when you look back in hindsight, you may say, gee, I might have rather had a third or 20% or 15%, whatever it is, of the big pie versus fight for 100% of pie, what we have called pie B here, because that's an ever shrinking target, and we don't ever know when it's going to stop shrinking. So those are very practical considerations for any probate litigation and any probate mediation. The problem is that human nature, being what it is, people don't necessarily make practical decisions in probate. This is not just about the money. H.L. Mencken said, when somebody tells you it's not about the money, it's about the money. Well, to some extent that's true, but in probate it usually is not just about the money, because the money touches people on a lot of different levels, and sometimes here it does it in the most toxic way possible, because the money, the stuff, the property is what's left of family and all the history and all the emotions and all the baggage that comes with that. Oops. Most probate litigation is going to be intra-family, and it's been my experience that there's a tendency on at least one of the litigants to equate how much mom loved me, how much dad loved me, by how much they were left, whether it's in terms of gross dollars or whether it's the family business or in terms of a percentage of the estate. And it's very difficult to accept having been excluded as a beneficiary. I mean, nobody wants to accept the conclusion that they were excluded because the decedent thought this out very carefully, very deliberately, and said, you know what, I've made the decision to exclude my child or my grandchild or whomever. You know, to put it another way, it's a lot easier to blame some external force, you know, whether it's another beneficiary like a sibling or a step-parent, that's a hot button, a neighbor, for something that really might be a shortcoming on the frustrated beneficiary's behalf, or in a shortcoming that he or she had in their relationship with the decedent. And, you know, that's why these emotions in these mediations run very hot. They are very personal.
And, you know, Mike, this also, real quick, brings to mind, I think, growing academic research and validity into the power of people's sense of fairness and what is the opposite of that, their view or interpretation of things as being unfair. And it might actually have an evolutionary component, and that can probably spill over into all of these, you know, perceptions, like you said at the outset on this slide.
Well, I think that's a very good point, and I think it's almost like asking somebody to define who's rich. Well, if somebody's rich if they make $1 more than I do. Well, who was treated fairly here? Well, if I got at least as much as everyone else, I was treated fairly. If not, I wasn't. And so that does happen. If the decedent is a parent of the competing litigants or a step-parent, you know, the heat of these emotions is going to be even more pronounced because the death of the last parent very often knocks down whatever thin wall of civility hostile siblings may have been able to maintain. You know, I've had cases, and you may have too, Richard, where you have to bring the competing litigants in through separate entrances or at separate times so they don't have to see each other. We have to make sure the path to the bathroom is clear so they don't run into each other in the hallway, and make sure that, okay, it's time for you to go get lunch. It's time for you to go get lunch.
Yep.
The parties don't want to have a joint session most of the time, and so we have to figure out those logistics. Now, if it ever gets to a point where either the lawyers or the litigants or the mediator feels that security is necessary for a mediation, keep in mind there is a MEAC opinion, Mediator Ethics Advisory Committee opinion out there, and it's number 97-004, that says if you have to go so far as to have a deputy there, you know, an armed deputy at your mediation because you're concerned about the ability to keep order, that mediation isn't happening. You can't do it. And, you know, you're setting yourself up really for a situation where nobody's going to be able to negotiate, or nobody's going to be able to negotiate exercising free will and self-determination and things like that if they are doing it in an environment of fear. So for you mediators out there, please be advised that opinion exists.
And that's opinion 97.004?
Yes.
Okay.
Yes. So we have a lot of logistics to figure out in these mediations. And, you know, if you think about it, on one level, this sounds silly because we are dealing with grown-ups, or at least chronological grown-ups. But, you know, there's an expression in family law, you see good people at their worst. And I think in probate litigation and probate mediation, you may be also seeing good people at their worst. So whether these are less than mature expressions of emotion, they're very real to these folks, and we have to deal with them, because if we ignore them, it dooms the mediation before it even starts. And when I say we have to deal with them, I'm not talking just about us as mediators, but I'm talking about the lawyers who are their advocates, and more important, their counselors as well. The primary emotions that we see are, obviously grief. There's anger at the adverse litigants, and that may be one way, and it may be mutual. And the anger, what's interesting when you talk to these folks, the anger may not have anything to do with the particular legal or factual issue in the mediation. It's a byproduct of the dysfunction that has existed in this family or between these two siblings or multiple siblings for forever and ever. When I say anger at the decedent, that could also be a sense of betrayal by the decedent, by looking at the will and having been excluded or gotten a greatly diminished share. How could mom do this to me? After all I've done for them over the years, how could mom do this to me? And so closely attached to that sense of betrayal by the decedent is anger at the decedent. But all of those orbit around the biggie, and that's a sense of entitlement. And if we can't get past entitlement, we will not accomplish anything in the mediation. Now, you have to recognize as the lawyers which one of these, or which combination of these emotions your client has. You got to figure out what's in this person's head, what's in this person's heart, and get them focused on solving the problem, because we're not in the mediation to fight a family war, and the court is not there as their alternative to be the battleground of a family war. If you're the mediator, you have to remain as uninfected as the client, as the lawyer, and figure out what combination of emotions are at play, because what everybody has to be able to do is keep the client, and this is primarily the lawyer's responsibility, keep the client from developing unrealistic expectations. Very often people will want to tell me, well, this is my bottom line. I'm not going to agree to let them have any more than this. I'm not going to agree to take any less than this. And if I think that's about to come out of their mouths, I tell them to stop. I don't want to hear it. I don't want to know it, because it's not my responsibility to help you get something at or better than your perceived bottom line. And your bottom line's arbitrary. I don't care if you calculated it. I don't care if you pulled it out of the air. It's arbitrary. If I get you within $1 of it, I know you're going to take it. If I get you within $100 of it, you're going to take it. But for me to have that information in my pocket either makes me have to help people go toward help them reach an unrealistic expectation, or feel like, as the mediator, I'm perhaps selling them down the river and taking sides with the other party when I don't. So I just tell them I don't want to know.
Yeah, I agree. I tend to try to wave people off from telling me their bottom line. The bottom line is important to them, so be it. If they insist on telling me, I make sure they understand, the ramifications, and then we keep going. But my predisposition is to not want to know the bottom line.
No, I agree with you. Now, it doesn't matter really, to me, how much time has passed after the death of the decedent that the mediation takes place to recognize and acknowledge that grief is still one of the very strong emotions at work. I assume that most, if not all of you listening to this have lost a loved one before, and you know how powerful an emotion grief can be. It affects people in different ways, but it's going to suck out your physical strength, it's going to suck out your mental strength, and you don't go from being grief-stricken to okay just like that. Grief isn't an event, it is a process, and our society memorializes that process with lots of different events and rituals. Now, there are some very well accepted phases of grief that were identified by I believe she was a Swiss psychiatrist named Elizabeth Kubler-Ross back in 1969. And, the general phases are denial, anger, bargaining, depression, and finally acceptance. And not necessarily in that order, although that is the order in which she wrote of them. And in a lot of cases, the process of grieving has been thwarted for one or more of the litigants by perhaps one of the other litigants or other family members. Think of all those, like I said, there are rituals that we attach to the grieving process. People will visit you or visit the decedent during last illness. And very often I hear, well, I was kept from the funeral. I was kept from the hospital. Nobody told me when the wake was or the funeral. In Judaism, people will sit Shiva in the house of the dead person for anywhere from 3 to 7 days. You may be kept from going into the family home. There may be some photographs, costume jewelry, real jewelry, things that should, in the ideal situation, be able to be divided between people. Keep these pictures of your parents, or go copy them, or this was mom's favorite brooch, and I know you've always liked it, why don't you keep it? Well, none of that stuff happens in many of these cases that end up in litigation. And so although it's kind of maudlin, a settlement is often going to be necessary to allow people to complete the grieving process and let them get on with their lives. Now, again, I said entitlement was the 800-pound gorilla in the room, and that slide showed you that's the emotion or the feeling around which every other feeling revolves. And the unexpressed statement is that, well, there was a parental relation or a filial relation, among siblings. Therefore, I, the litigant, am entitled to a particular portion of the estate, or even all the estate. Well, I still have my law school casebook from estates and trusts. And Richard, I know you went to the University of Florida, as I did, and you probably have the same book. It's called Gratuitous Transfers.
Yes.
And that says it all. Whether you're talking about, now, other than homestead or elective share, things like that, or intestate succession. The title of that book says it all. A bequest, an inter vivos gift. They're just that. They're gifts. It's something that's done without consideration, and therefore it's done without obligation. There's no right to a gift. There's no obligation to make a gift, and therefore there's no right to receive a gift.
And I will also say that No amount of highlighting, tabbing, and dog-earing and writing notes in the margin increase your odds of a really good grade on your final exam during that Estates and Trust open book test. Sorry, you brought back a bad memory.
Well, I liked the class. I don't know about you.
I liked the class. I just didn't like the test.
You know, I find it helpful sometimes to ask people, well, okay, if Mom had left everything in her will to the Humane Society or her church or, you know, pick a charity, what would you have to complain about? Would we be here today? Almost always the answer is no, we wouldn't be here today. And from that, I mean, I draw a couple of conclusions. And the first is that deep down, people know, at least on an intellectual level, that now they don't have a right to a gift. And that oftentimes the will contestant is not so much upset by the fact that he didn't inherit, but he's very upset by the fact that the other person did inherit. And so it's like a variant on the old Tommy Smothers tagline. You know, he said, "Mom always liked you best." And so it's not so much that I didn't get it, but it's that you did. Now here are the matchups that we see almost all the time in probate litigation, and I'm taking out of these cases instances where a charity might be a party or something like that. But I'm dealing with the ones here that are, I think, more likely to happen, and the ones that have the most emotional turmoil. You can have siblings against siblings. You can have siblings against, children against the parent's boyfriend or girlfriend, or against the caretaker, or against whoever held power of attorney for the parent. Or if we got beyond boyfriend and girlfriend and the parent remarried and now there's a step-parent, and heaven forbid maybe even the step-parent has children, and so now we have two sets of children. We can have children versus surviving step-parent, or children versus surviving step-parent and the step-parent's children. But the recurring theme here is that there's children all the time in every one of these examples. And they are the ones who are most likely to have the sense of entitlement. The two most likely litigation issues, at least that I run across, and Richard, if you have run across others, you know, jump in. But one is lack of testamentary capacity. And the other is undue influence. You know, every once in a while you will run across an issue about whether a will was properly executed. In other words, did the testator sign in the presence of two witnesses who signed in the presence of the testator and in the presence of each other? You may have an issue over reestablishment of a lost will. Or sometimes people will create a living trust and then never fund it. And did they intend to fund it? Did they? There may be some loose language in the documents left behind reflecting their assets as to whether something was a trust asset or not.
Yeah, you hit the two biggies for sure, and those both are tied to, you know, that notion of, you know, Mom could not have meant that. Both of those, undue influence and lack of testamentary capacity, you know, touch on that.
Right. Mom was either crazy, or if she wasn't crazy, someone worked their magic on her. And so these really are the two that are that we see the most. And generally speaking, probate litigation is going to arise when an interested person, usually the personal representative, offers the will for probate. One or more interested persons objects and files a petition to revoke probate. And so if we look at these, these two issues, the ones we're most likely to see, you'll see them pleaded together in virtually every petition, count one and count two. But they really have to be pleaded in the alternative, because if you think about it, lack of testamentary capacity and undue influence are really mutually exclusive. An undue influence claim essentially concedes that, yes, the testator had testamentary capacity, but the allegation is that his or her free will was overcome by the undue influence of someone else. And, if you look at the statutes that deal with fraud, duress, undue influence, it doesn't necessarily have to void the entire document. It can void only the part that is the product of undue influence. And so since by statute there's a recognition that only part of a testamentary document could be set aside for undue influence, that would suggest that that the testator did have capacity as to the rest of the document. So let's talk about the first one, testamentary capacity. This is not a real high standard. I think I hear people call this the three-legged stool. The testator has to have a general understanding of the nature and extent of the property to be disposed of, what you often hear referred to as the natural objects of the testator's bounty, who would naturally be expected to benefit from the will, and then what the practical effect is of the will as it's been executed. And it's important to keep in mind, too, that testamentary capacity is determined solely by the decedent's mental state at the time the will is executed. So again, this is not a real high standard. This is a lower standard than capacity to contract. Even a demented person, an insane person, can execute a valid will during a lucid interval. There's a very strong presumption of testamentary capacity under Florida law. So if your will contestant, if your client is basing the will contest on a lack of capacity, keep in mind that that client is going to have the burden of proving a negative. They're going to have to prove, and that is carry the burden of production and persuasion, that the testator lacked testamentary capacity. So again, you will see it pleaded all the time, but it's a lot harder to it's harder to prove than it is to plead. Now, undue influence, I think, is a much more promising approach for the opponent of the will. If you think about this, proving lack of capacity, again, requires proving a negative to overcome a very strong presumption. Proving undue influence, on the other hand, requires making a prima facie case sufficient to raise a presumption. And when it comes to lack of capacity, you're dealing with proof of actions really only of the testator. What the testator said, did, how he or she acted at the time of execution of the will. We're really not looking at the actions or inactions of other people, but when you're dealing with undue influence, you can prove that by adding in proof of actions of persons other than the testator, caretakers, neighbors, children, stepchildren, things of that nature.
So the field of potential evidence is broader.
Yes, it is. Whoops. All right, let's get to our correct slide. Here we go. So as I said before, undue influence effectively concedes the existence of capacity, but there's a claim that the will is going to be the product of undue influence, the elements being active procurement of the will by a substantial beneficiary who occupied a fiduciary or confidential relation with the testator. Now, I'm trying to come up with what a fiduciary or confidential relation is, but it's a very broad definition in Florida. We go all the way back to a 1927 case, which is the one you hear cited the most often, called Quinn versus Phipps. If you want the site, it's at 113 Southern, 419. And they say the origin of the confidence is immaterial. The rule embraces technical fiduciary relations and those informal relations which exist whenever one man trusts in and relies upon another. It doesn't have to be a legal relationship. It may be moral, social, domestic, or purely personal. Now, this is a very sarcastic website, but it also has it also has a lot of very good information on it. And it's, if you can't read it, I couldn't change the color of the font here, but
it looks clear.
www.steelandestate.com, and it talks about ways in which you can, in which one can create a fiduciary or confidential relation, and ways in which you can begin to unduly influence those with whom you have that confidential relation. And again, it's written as a how-to guide, but it's written by victims of frustrated beneficiaries, really, of undue influence by caretakers, by step-parents, things like that. And I have to credit a friend of mine, Don Hawkins. He's a very well-respected probate litigator here in Daytona Beach, and he's the one that told me about this website. And again, it's very sarcastic. Don't take it as a serious how-to guide, but it does show how people create the relationships and then actively procure both inter vivos and testamentary gifts for themselves and for their families. For those of you who practice in the estates and trusts area, you know that the indicia of active procurement that will create a presumption of undue influence are found in the Carpenter case from 1971. And there are some very well recognized factors from that case. I didn't list them all out here, but the big ones are being present, the beneficiary being present at the execution of the will, being present when the testator expressed a desire to make a will, recommending the attorney, knowing what's in the will prior to its execution, securing the witnesses, or safekeeping, or the beneficiary keeping the will in safekeeping after it's signed. Now, I said before this is a more promising avenue for attacking the will, because a presumption of undue influence, if it does arise, is a presumption that shifts the burden of proof. And that is by statute, Florida Statute 733-107, and the Hack case from the 5th District. Now, we all know that there are two kinds of presumptions. We have what we call the bursting bubble presumption. If you make a prima facie case of, say, under Carpenter, if you made a prima facie case of undue influence, then the proponent of the will had to come forward with evidence to rebut that presumption, at which point the presumption went away, and the opponent of the will then had to prove the existence of undue influence. Well, now, and that's a bursting bubble presumption. The presumption's gone. But now, once that presumption is raised, according to this statute and the Hack case, this is a presumption that shifts the burden of proof. So now the proponent of the will, the personal representative in all likelihood, has to prove the non-existence of undue influence. So for the same reason lack of testamentary capacity is hard to prove, you got to prove the negative. Well, now the proponent of the will has to prove the non-existence of undue influence. So he or she has to prove the negative. And once that presumption is raised, there's case law that says, well, you can't determine that case anymore by summary judgment, so you are on your way to a bench trial. Now, there's only one oddball case that I do want to mention, and it's a case out of the 5th District. It's called Arnell versus Fisher, 647 Southern 2nd, 1047. And this was, you have to applaud the opponent of the will for creativity here. You have a testator who was suffering from terminal cancer, being tended to by a nurse. A few weeks before he was discharged from the hospital, the two of them get married. And a month after the wedding, he signs a will naming his new wife's 4 children as the beneficiaries. He had never met them. Well, he had met them once, probably at the wedding. He dies 9 days after the will is signed. So they have a 41-day marriage. The wife goes to administer the will. The nearest heir at law of the husband would have been his cousin. And so his cousin files a proceeding not only to revoke the will, but also to void the marriage, saying that the marriage was procured by undue influence. Now, the court never did get into talking about the circumstances surrounding the execution of the will, but the 5th District, as well as the trial court, said, look, cousin, you can't challenge the marriage. Even if it's procured by undue influence, it's not void, it's voidable. But a voidable marriage is good for every purpose, and once either spouse dies, it's good forever. So, again, we have to applaud the litigant or the cousin for trying to set aside the marriage, at least for creativity points, style points. But that's an oddball case where it didn't work.
Based on style points, it sounded a little bit like a law school exam fact pattern.
It does.
And that was 647 Southern 2nd, 1047?
Yes.
Thanks.
Yes. Now, with that little bit of legal predicate, I want to touch on the ways in which we can best make a probate mediation succeed. The first one is this: real simple. These take a long time. They just do. They either blow up right away and take 15 minutes, or if they have a chance of success, they take a long time. Don't schedule them to start in the afternoon. We got to start them in the morning. I mean, it is not uncommon in my experience to start these at 9 in the morning and, go into the evening, go into sometimes the next day. We may end up doing the, follow-up over a period of, of weeks or even months. But we may have multiple sessions that take the entire day, and I mean more than a working day, maybe a 12-hour day. I've had them take even longer than that. And so I would say discourage your client from having to go catch a plane the same day as the mediation. And both the mediator and the lawyers need to accept the fact and be ready for the fact that at least one, if not all the parties, are going to spend a lot of time in caucus venting, because they either have so much confidence in their own position that they have to tell you what a stinker the other person is, or they just feel absolutely powerless and they need to be heard. Now, one thing I do want to say about the length of the session, there's the case I cited earlier, the Pierce case. They started the mediation early on Friday. The case went all day. Everybody's represented by counsel, but at some point the appellee said, "I'd really like to take the proposed agreement home for the weekend to review it before I sign it." And for whatever reason, that was given short shrift. But she did sign it. She didn't take it home, but then she went to the mediator's office on Saturday, and I'll certainly mediate a case on Saturday if you want, but I'm not typically going to just be here, and I don't know who she was thinking she'd find. But she sought to rescind the agreement right away, and the trial court rescinded it and said, you know what, you asked to review it, that request wasn't granted, and she acted right away to rescind, so she didn't freely, knowingly, and intelligently enter into it. Now the first district said, no, sorry, that's a valid agreement. You may have been tired, you may have been distressed, you may have had buyer's remorse, but that does not provide grounds for setting aside the agreement. Now, that being the case, as the mediator, we have to be careful to make sure nobody's getting too tired. That is really long sessions.
Can I interject?
Yes, go right ahead.
Some of our listeners are from out of state, and we're talking about how to make the mediation succeed. We did have one question about from an out-of-state listener about whether the personal representative who is not the primary beneficiary should move for mediation.
Well, if you're talking about Florida, that's a pretty straightforward question because they're not going to be put in the position of having to make the decision. Florida will send virtually every case to mediation. We kind of have a built-in market that way. So the question really becomes one of timing as opposed to whether you're going to mediate. It's really when are you going to mediate. And I think you mediate when you have enough information to make intelligent decisions about what to do, without necessarily discovering the case to death. You don't have to do everything you can possibly do, because if that's where you are, why not just go try the case? But there's a point at which you can get enough information to go have a meaningful settlement discussion. And so at that point, I think you go ahead and schedule it. but at least in Florida, you're not going to really have a choice over whether to do it. When we get into the caucuses, and again, we usually will not have had a joint session very often, please let your client vent. If we do have a joint session, don't let them do it in the joint session. That's going to shut things down. But there is a catharsis that goes on by venting. I've had people crying in these caucuses. We have a box of Kleenex in every room, but they need to do it. And I'll let people go on, at least in these early sessions, for as long as they need to get things off their chest. And one thing it does for me, it gives me a lot of insight into the opposing party. I want to know, are they educated, what kind of work they do, what kind of relationship everybody had while they were growing up, and what motivates them. Does money motivate them? Does control motivate them? And I want to know the same about the client that I'm sitting there talking to. Are they sentimental? Are they looking for money? Are they looking for revenge? Just what? And that allows me to categorize these clients. And I think of them in three categories, 1, 2, and 3. Category 1 people are the ones who want to settle. Category 2 are the ones who don't want to settle. And then category 3 are the ones who affirmatively want not to settle. There is a difference between 2 and 3. And it's, notice the phrasing. Very rarely are you going to have 2 category 1 litigants. If people on every side want to settle, they're going to have resolved this probably without ever even having filed adverse proceedings in probate. So these are the people who recognize that, we want to let bygones be bygones. We can't change the past. Let's look forward, not backward. And just get this behind us. So they see both the economical and the emotional utility of putting things behind them. Now, if you have a category 2, what I call category 2 people, somebody who does not want to settle. Well, why don't they want to settle? Well, very often it's because they think that the opposing party's position is legally weak and factually weak. Of course Grandpa had testamentary capacity. And no, there was no undue influence. Yes, I was there taking care of Mom every day, but you know what? That's because you live in Seattle, Washington, and you weren't doing anything to try to help. You weren't coming to visit. You weren't calling. You weren't, you know her phone number. You know where she lives, but I was the one on the ground taking care of her. And so, they may see it as an attempt by the opposing party just to extort, if you will, some money out of the estate. Now, they may still be willing to settle, but they got to be brought around to the idea. I mean, most people come into mediation thinking they're right, and so they don't necessarily want to settle. But you can still get those cases settled. The economics have to justify it. And they have to be able to walk away, I think, with some perception of a win. We'll very often say in mediation, well, we're looking for a win-win, but we all know that people leave kind of disgruntled, feeling like they might have left something on the table. But in this instance, yeah, I think these people do need to be allowed to feel like they won something. And most of the time, you're going to have at least one Category 2 litigant in these cases. And from the mediator's standpoint, that's fine. We settle cases with people who don't want to settle all the time. And as lawyers, you advise people about the utility of settling financially and financially, emotionally, whatever. And, you get people past their initial reluctance all the time. So those cases can settle. It's the people in Category 3 that really present the problem, because litigation is supposed to come to an end. Problems are supposed to get solved. These people don't want litigation to come to an end or the problem to get solved, because solving the problem creates a new problem for them. And that the problem being, now they're deprived of the ability to make the other side miserable. So there is an intangible benefit these people get from continuing to litigate. And there's a word for it. I think I'm pronouncing it correctly, Schadenfreude. And it's defined as the pleasure derived from the trouble of others. That's why we stop and gawk at a car accident. Think about it. If I'm not getting it, you're not getting it, which could roughly be translated as the lawyers will get it. I'd rather pay my lawyer.
And Mike, on the theme of bringing things to an end, we have about 8 minutes left.
Okay, that's fine. We'll get through that.
Just wanted to let you know.
Well, and I would challenge all of you as advocates and counselors to think about how you handle your clients who are motivated by, you don't have to call it Schadenfreude, call it spite. One of the things I like to ask people is how the decedent might react to the tactics that they're taking. How would your dad handle this, or your mom? They worked hard for this money, and do you really think they intended to make your lawyer a beneficiary, or the other lawyers beneficiaries? I try not to get quite that sarcastic, but I do try to get them thinking about what their parents, or whoever the testator is, what that person would think, how that person would advise them to proceed. Now, I'm assuming that there's a certain degree of rationality in this person, and usually there still is. I mean, just because they affirmatively don't want to settle doesn't mean they're irrational. I mean, they might be, but not necessarily. I do think we have to keep reinforcing to the clients the fact that that pie is shrinking. Now, if it's a Category 3 client who affirmatively does not want to settle, that might be throwing gas on the fire. That might be exactly what they want to know. For a Category 2 person who needs to be brought around to the idea of settling, talking about the size of that pie today versus a percentage of an unknown sized pie tomorrow might be powerful. As far as somebody who affirmatively doesn't want to settle, there are still a few things we can talk about. At some point, maybe that person can be made to recognize, hey, your opponent has suffered enough. Now you got to find a nice way of saying, now you're just kind of pulling wings off flies. It's time to declare victory and go home. Be a good time for the lawyer to tell the client how big a trial retainer he's going to need to pony up, if there's not a settlement. And if that litigant is a fiduciary, okay, you may affirmatively not want to settle, but if you're a fiduciary, if you're the personal representative or something like that, there's always the specter of a surcharge. Or if you're taking far too unreasonable a position, there may be the potential of attorney's fees under 57105. And if that becomes a possibility, you may very well be losing your lawyer as well, and that's a point that isn't going to be lost on the judge. Let's talk about real estate for just a minute. If there's a devise of real estate,
Mike, I don't know if it's your computer or mine, but I'm getting just a little bit of static right now. So if it's anything you could control on that end, that would be great.
Okay.
And
well,
if it's my computer, we won't worry about it.
All right. I don't think I've done anything different, but you let me know if it continues. If you have a devise of real estate, there are some additional issues that need to be considered at any mediation. One, the market may stink. The value of property is going to be uncertain. It's going to be prone to fluctuation. If it has descended as homestead so that somebody has a life estate and the adverse litigants are vested remaindermen, then you really have some valuation issues. Even if you're tenants in common, you're either going to be facing a partition action at some point, but as tenants in common or life tenant remaindermen, there are carrying costs that are going to have to be allocated one way or the other, and then there's always the question of whether anybody can afford to buy anybody out. But if there is money to do it, there are some better ways short of a partition to dispose of real estate. Now one thing you can do, you can always list it with an agreed upon broker and just keep reducing the price every 6 months or 3 months until it sells. But there are a couple of other things you can do, and let's just assume here we have two parties, and let's assume that they are willing and able to either buy or sell the other's interest. So we can have the old I cut, you choose, like two kids fighting over the last piece of cake. One party picks a price at which he's willing either to be a buyer or a seller, and the other party decides whether to be a buyer or a seller at that predetermined price. Now, if you do it that way, that's called Russian roulette, because one person picks the price, offers to buy or sell, the other person can elect to buy or not buy, but by refusing, he has to offer his interest to the other person at that same price, who has to accept. Now, you can also do this in multiple rounds until you agree on a number. The advantage to the process, no matter how you do it, it inherently requires that the party who submits the price to be fair, because otherwise, by cutting, you're going to lose. You want to cut as close to the middle as you can, just like you would with a piece of cake. And then there's another tactic called the single bid reverse Dutch auction, and this has its genesis in the poppy auctions that took place in Holland several hundred years ago. And in this process, each party submits one sealed bid to the mediator, and that is the price at which she is willing to either buy out the other party's interest or sell her own. So each one submits a sealed bid to the mediator. The mediator opens each envelope, and the high bidder is the winner. The high bidder gets to purchase at the price set by the low bidder. Now the advantage of this, and this is really good in a soft real estate market, it encourages high bidding, and therefore that's going to maximize the value of the property. And you don't want to risk bidding too low, because then not only would you not get to would you not be the winner, but you would have to sell at an artificially low price. And so it encourages everyone to be at
Mike,
a minimum fair, at a maximum overly generous.
Mike, can I interject real quick?
Yes.
I know everybody who has joined us has set aside a certain amount of time, and we'd like to continue discussing this. But before we do, could you switch to the slide real quickly where listeners can see the CLE numbers, so those who have to break away at 12:15 can do that, and then we can come back and finish up from slide 28.
Well, we actually are finished, because we can see we are at the conclusion side. Keep reminding your client about the benefits of settlement. Remember, you can offer photos and keepsakes, and that'll get you a lot of bang for your buck. And above all, be patient, and that applies to client, lawyer, and mediator. And that brings us to the end. I'm going to back up to this slide in just a minute for those who can stay for just a moment. But here is the course number you've been coveting. This is good for 1.5 hours of CLE and an hour of certification in elder, marital and family, or wills, trusts, and estates. And that does bring us to the end of our webinar. I'm going to back up one slide for just one moment. I did write an article recently about successful mediation in probate. If you go to this website, bit.ly/probate, and I think there's an underscore Orfinger, it will take you to an article published in a newsletter called Alternatives to the High Cost of Litigation, and it's called Mediating Probate Cases to Settlement. So with that brings us to the end. Whoops. And I do thank everybody for attending. If there are questions that you want to submit afterwards, please email them to Richard. Please email them to me, and we'll try to answer them offline. But other than that, I think we are finished. And I do thank all of you for attending today. And Richard, thank you so much for moderating and
well, Mike, thank you very much.
Joining me. It was fun.
Again, this is Richard. Yep.
Did we lose you?
Well, thank you very much for putting it all together. It was very insightful and helpful, I know, to the night. Hopefully, it might be a problem on my end. Again, thank you, Mike. Thank you to all of you who joined us. And for those who might want to retrieve this later, we do have an archive on our website where we maintain quite a library of webinars that we have put together over the months and years that we've been doing this. We invite all of you to visit our website and look at that library and keep your eyes out for future webinar topics that we will be able to share with you. Again, Mike, thank you very much, and this concludes this webinar.
All right, thank you, and thanks, Richard.
Thank you.